very much for being here. We're very excited that all of you are participating in the event today. Thank you, Sajjad, for the introduction to SICA and the Young Arbitration Group. I'm very pleased to be here today to moderate a fantastic panel. We have worked very hard in putting this panel together for you all, and the topic is, I don't think, could have been any more timely on Pakistan's experience in investment arbitration, how to revisit the approach and rise to the challenges. So at the time, actually, that we put up the panel together, two things didn't happen. One was the settlement that recently happened with the Karke arbitration, which is a huge deal for Pakistan, which we're going to talk about a little bit. And the second was the record date award, which also didn't happen. So I think there's a lot of discussion happening that we need to address. We have a fantastic lineup of speakers here today. Some of them are physically here, and some of them are going to be technologically here. So I think we can connect Ruba now as well. So I'm going to start by introducing them really briefly. So we have Manaz Malik, who's in my immediate left here, who's a barrister at 20 Essex Street. Manaz is, of course, a barrister and arbitrator, and she has acted as counsel on behalf for both investors and states in several investment and commercial arbitrations, including ICC, ICSID, LCIA. She's been appointed as an arbitrator in the Eurogas and Belmont Resources versus Slovakia case, and she was the youngest ever appointed arbitrator to an ICSID annulment committee. And I'm just stressing this out because she is a Pakistani woman, and I think we have to appreciate that she is the youngest member of ICSID, which is a very prestigious place to be appointed as an arbitrator for starters. So terrific experience here. We also have, of course, Sarah Bassani. Sarah is a partner and head of the investor-state dispute resolution practice at Al Goddard, who is one of our sponsors today. So thank you again for sponsoring. She's currently acting as lead counsel for Pakistan in an investment arbitration case under the Organization of Islamic Conference Treaty. So that's going to be an exciting experience that we can talk about as well. She specializes in both international commercial arbitration, investor-state disputes, and she represents clients before the major institutional rules. And she also acts as arbitrator. We also have Faisal Naqvi, who is a partner, and Madariya Naqvi. He's a graduate of Princeton and Yale, and before working in Pakistan, he worked several years in New York at Fried Frank, and he has significant experience in investment arbitration and arbitration generally, not least because of his involvement in this water treaty disputes that involve Pakistan, so that is also a major experience here. And we're very much looking forward to him being on the panel and presenting his views. And last but not least, thanks to Skype and modern technology, we have Ruba Gandour, who is assistant legal counsel at the PCA in The Hague. And she's going to provide us with an institutional perspective from the Permanent Court of Arbitration. And Ruba has also significant experience in arbitration because before working at the institution at the PCA, she was working in several international law firms in London. I'm just now. I think it's time that we start the discussion. We have broken down the discussion as follows. So Manaz is going to start with a historical overview of Pakistan's experience in investment arbitration, and then we're going to have Faisal, who's going to give us a little bit more examples of Pakistan's VATs, substantive obligations, and also their experience giving examples of specific investment arbitration cases. And Sarah will provide us guidance on how can we prevent disputes, right? Because disputes are not good, contrary to a popular belief that it is good for lawyers to bring disputes in. No, that's not true. We're not looking forward to that. And so Sarah will give us tips to prevent disputes. And Ruba will give us the institutional perspective on how to make proceedings more efficient. So, Manaz, you leave the floor. Thank you very much.
Thank you, Sadia. Assalamu alaikum and good morning, ladies and gentlemen. It is a pleasure to be here this morning on a panel that discusses international investment law Rana Sajjad has already told you that this figure of $6 billion is something worth your attention this morning. I'm delighted to be speaking here. I understand that 64% of Pakistan's population is under the age of 30. So it is a real sort of pleasure to be able to share some of the historical perspectives on how we got here with bilateral investment treaties and the $6 billion number that Rana Sajjad quoted. That is one of the 600 recorded investment treaty claims we know about. But to use a Marvel analogy, this is the origin story of BITs. And we're doing it the right way around. We're starting with the origin rather than starting with an end game. But I will leave Sarah and Faisal to speak about what happens later. As you know, there are just shy of 3,000 bilateral investment treaties today. And it all started on a cold day in Bern on the 25th of November 1959, when the first bilateral investment treaty was signed between Germany and Pakistan. And that is where this particular conference gets even more interesting, because the history of Pakistan's bilateral investment treaties is linked with the history of BITS at large. So let me take you back to that time, that cold day in Bern in West Germany, when S.A. Husney, the then Foreign Finance Secretary, was signing the world's first bilateral investment treaty. Of course, S.A. Husney, who was a civil servant of the old school, as I'm reliably informed, went on to sign greater things. He became the governor of State Bank of Pakistan and signed, obviously, the currency notes. I don't know if anyone's here that remembers that, but that is what S.A. Husney did. And I've often wondered that when he was signing this bilateral investment treaty, whether he recognized the landmark event that had just occurred. Because based on that template, over 170 countries would sign nearly 3,000 legal instruments. That would result in consequences in terms of massive awards worth millions and billions of dollars. I've also wondered whether Pakistan was taking a very progressive view on attracting FDI at the time and putting those commitments down in an internationally binding instrument, or was it an unsuspecting guinea pig, to put it more crudely? What is interesting is a year later, Malaysia signed a bilateral investment treaty with Germany, and others followed. The precedent was set. But I should caveat that. The first bilateral investment treaty had a key component missing, and that is the investor-state arbitration clause. Everything was set except that particular piece of the puzzle. That came in 10 years later with the state clause, and that was between Chad and Italy in 1969. But I'll jump ahead. There is another significant development between 1959 and 1969, and that is the signing of the ICSID Convention. You'll hear more about ICSID, but that is the World Bank organ that provides for adjudication of investment disputes, and it is the most well-known one, but I'm sure the PCA is coming up, but that's what we associate, at least with the ICSID Convention. But a lot of people assume that the world's first BIT, as I mentioned, was signed obviously between two countries. That's why it's called a bilateral investment treaty. But the template that you see in that BIT, save for the investor-state clause, is remarkably identical to the 3,000 odd treaties that followed. So if either of you have nothing to do one evening, I suggest you look at the most recent treaty signed by Pakistan or any other country and compare it to the first BIT, and you'll see that the obligations are remarkably similar. So the blueprint was cast in 1959 by Pakistan's hand, or better or worse. A lot of people assume that the origin of BITs lies in some grand meeting of states a bit like the WTO, which is obviously the trade cousin of this regime. But actually that's not true at all. Its origins lie in the private sector. In 1958, a group of German businessmen, who still exist actually, I had the pleasure of addressing them a few years ago in Frankfurt, commissioned Abs Herman, who was the former chairman of Deutsche Bank, and Lord Shawcross, the former Attorney General of the UK, to create the draft of an international convention that would protect them against the regimes of communism and nationalism following decolonization. So European businesses were very concerned about what was going to happen in the 1950s and 60s to their investments. And they got the best, a fantastic banker and a great lawyer to come up with a draft. And they did. And that draft is remarkably similar to the BIT that Pakistan and Germany signed. Now, to use another rather inelegant analogy, which I'm sure a lot of the advocates in this room are familiar with, like the proverbial frog being boiled, the heat was turned on very gently. Bits, hardly any in the 50s, save the one that I mentioned between Pakistan and Germany. And in the 60s, we had a handful. Really, we were looking at hundreds in the 60s, 70s, and 80s. The real surge in BITs came in the 1990s, when almost 1,000 BITs were signed suddenly by a range of newcomers. India, for example, signed its first BIT in the mid-90s. You had the newly independent Central Asian states that were coming into the game. And this was really propelled by a combination of liberalization in these newly independent states or countries that were changing their economic policies, the World Bank pushing for these instruments, and UNCTAD facilitating their signature to signal that the country was welcoming FDI. And suddenly, the easiest thing became to sign a BIT if you wanted to say, well, we welcome FDI. What was perhaps not entirely known at that time was that these instruments were quite remarkable. They are one of the few instruments in public international law that give private individuals the standing to sue a state before a tribunal. And that is a huge revolution that took place very silently, again. And that happened in 1987, when the first claim under a BIT was registered, and the first award followed in 1990 against a neighboring country, Sri Lanka. And that's called the AEPLB Sri Lanka case, and that's the first BIT award. When we finally recognized that these instruments that countries were signing in the last few decades actually had consequences. And I often wonder if this award had received the type of publicity, I guess, what you would get now, whether you would have that surge of BITs that followed. Because that case is actually quite curious. It really challenged the state's sovereignty right to its limits. It involved this pursuit of Tamil Tigers, an anti-terrorist group, on a shrimp farm of Sri Lanka. And the tribunal found that Sri Lanka hadn't taken adequate measures in relation to this particular anti-terrorist operation, which resulted in the destruction of the shrimp farm and unfortunately the deaths of some of its employees, and was ordered to pay compensation. Other claims followed, but slowly again. Around 2000, when I started practice, there were about 50 odd claims. And now you have over 600 recorded cases, and I would hazard a guess as to how many have been registered. Some say over 1,000. It's a bit like an urban legend. You don't really know how many because only ICSID makes them public. I'm sure Aruba can tell you a little bit more about what the PCA does with data consumption. So, Pakistan's history of BIT claims is something I need my friend Faisal Naqvi to tell you more about, but around the same time as the rest of the world was facing an increase in BIT claims. I mentioned the number of 50, but these were to increase quite exponentially over the next 15 odd years. Pakistan also got its first generation of BIT claims, SGS, Abdul Bayinder, that was the first generation. And you see a correlation to the BIT slowing down in the 2000s. So as more countries started facing claims, less BITs were being signed. And that's also reflected in Pakistan's policy. And during this time, having had the privilege of representing both investors and states, it was quite interesting to see Indonesia was active, who I was acting for, and the Czech Republic, who I was against, say the same thing. Why did we sign these treaties? Who signed it? And without naming any names, rather embarrassingly, where is that treaty? And policies changed. South Africa, India, Indonesia started to claw back their BIT programs. Pakistan, interestingly, paused for a while, and to give due credit, resisted the pressure from the US government to be, perhaps what was clearly intended to be a guinea pig for their new extensive and expansive model BIT. The US pursued Pakistan heavily for this treaty, and I think for policy reasons, the Pakistani government resisted that pressure. But then Pakistan started signing BITs again after 2010. Another one with Germany, and then with Kuwait. Pakistan now has 48 treaties, if the Board of Investment's website is to be believed, and the OIC Investment Treaty, which is a multilateral investment treaty between several OIC countries. And to quote a familiar expression, we are where we are. And Sarah will tell you more about what to do with these treaties, because the fact is, they're here to stay. Even if you claw back, there are extensive clauses that allow for post-termination BITs to stand. So whether you have 48 as a country, or whether there are 3,000 globally, they are here to stay. And I think after 60 years, countries, including Pakistan, need to make their peace with the treaties. And I think the starting point is recognizing what they mean, and to find out if within that framework we can harmonize domestic policy and deliver on those international commitments, because ultimately as a sovereign nation, you've decided to do it, for better or for worse. And then, if you don't like what they say or what they do, to figure out a way, a policy ahead, to get out of them, or to stay in them. That is the discussion that needs to be had. And I'm delighted that we are able to leave it in the hands of the next generation, because Pakistan had a very integral part, as you know, to play in the signing of the first BIT. And I'm very hopeful that all of you around this table and the others who haven't made it to the conference will continue to make their mark in the history of bilateral investment treaties. Thank you very much.
Thank you. Thank you very much, Manaz. Faisal?
Good morning, everybody. Before I begin and say what I have to say, let me just preface my remarks by saying that since I have a somewhat contrarian view on BITs, my remarks are about bilateral investment treaty or investment treaty arbitration. They're not about international commercial arbitration, which I think is a wonderful thing, in which Pakistan obviously needs to adopt, precisely because BITs are so problematic for us. I'm going to make 3 points regarding BITs. The first is, they don't work for Pakistan, and given our history, our governmental traditions, they're not likely to work. The second point is, we need to get out of the ones that we already do, and we need to try and discuss how. And thirdly, we need to come up with a better way of dealing with the problems that we already have, which are in the pipeline. Now, the theory behind a bilateral investment treaty is fairly simple. Both, it relies on, in terms of incentives. So there's an incentive for investors and there's an incentive for states. The incentive for investors is that if you come to Pakistan, you come to a signatory country, you come and invest here, we guarantee you fair and equitable treatment, and if we misbehave, you get to go to international tribunal. That's wonderful. Investors are all happy. The flip side of that is that the state is told that if you don't misbehave, you will be punished. You will be penalized. There will be awards given against you. That part of the equation doesn't work in Pakistan. We don't recognize that as a problem when we are signing them. We don't recognize that as a problem until and unless you wind up with something like a $6 billion award. And it's interesting just for a minute to step back and think about why this is so. The assumption that there is some sort of a unitary state in which a government servant signs a piece of paper and automatically and mysteriously and magically all other government servants are brought up to an international standard of governance. It's just that. It's magic. It's a myth. It doesn't really belong in reality. Those of my friends out there, and I see former Advocate General Punjab, Asma Hamid there, other members of the government, former members of the government. When you actually deal with the government, the people out there are making mistakes so basic that you want to go out there and bang your head on a wall repeatedly every single day. So we are not going to ascend to first world levels of governance just because some piece of paper is signed. And this is a historical issue. It's a long debate. I don't need to necessarily get into that. But there's an English traveler to the Mughal Empire back in 1604, who wrote about how the emperor regarded merchants as so many sponges to be squeezed. That's the phrase, so many sponges to be squeezed. That remains true for Pakistani jurisprudence dealing with businesses till today. And I'm not talking about international investors. International investors are just sort of more of the same so far as the government is concerned, the eternal state is concerned. So we have, to give you an example, there was this whole development of a doctrine of promissory estoppel in Pakistan. We overruled that. And if you've been looking at, for example, our main cases, some of which have resulted in BIT cases, some of which haven't. To give you an example, the steel mills case. I had the privilege of drafting the review petition, which was dismissed many years later. But it's economically, the reasoning that you must take into account both the liquidation value and the discounted cash flow value for those of you who deal with these issues simultaneously is ludicrous. In the Karki Award, we again have an international tribunal pointing out that this is an act of expropriation by the Supreme Court of Pakistan. And we're not even talking about domestic judgments in which you have the same problem over and over again. For example, the Jamshoro Joint Venture Limited thing in which a project is set aside 10 years later because the bid bond was submitted a day late. I'm involved in both of these cases, so just heads up, I'm biased on these, but still. In the Royal Palm case, my client's property was taken away, again after 18 years, because the government failed to advertise the project properly. Now, if you had, as a state, as a country, actually recognized the protection of commercial expectations of the value, you wouldn't have these types of judgments, but you don't. Those of us who are practicing Supreme Court lawyers and have survived the past year of the former Chief Justice, since contempt of a retired judge is also contempt, I won't go any further, but it was a very interesting experience. Certainly rewrote a lot of commercial law in Pakistan. But let me come back to that point. If you think that because we will sign this, the state will behave a certain way, that's not going to happen. It's a nice theory, it doesn't work in practice. And if you look at the way we've actually done things, and we look at our actual cases, you will see this problem arising time and time again. In the Rekodik case, the actual event which occurred, and as per the judgment, which is now a matter of record, is that back in 2008, the government of Balochistan decided that it wanted this project for itself. This is what the award says. I'm sure my learned friend Manaz Malik would have a different perspective, but that's what they found. Was that a decision made at the highest levels of the government? Possibly, possibly not. But once you're committed, now all these years later, we're having to defend this, and again, I'm a counsel in that case as well, but you have this problem recurring. And my point is, as a state, we still don't take this as seriously as we should. Manaz mentioned the Pak Kuwait BIT. Let me give you some facts on that. I think that signed, if I remember from memory,
Valentine's Day. Valentine's Day.
Valentine's Day, 2013, in the last few months of the then PPP government. It's one of the few BITs which I think happens to be retrospective. 1 month after it's signed, the Agility company, which happened to have a $64 billion lawsuit against the FBR, which happens to be a Kuwaiti company, files its exit claim. Pakistan nominated, I think, a gentleman who was a labor lawyer from Pindi. He didn't make it to the first 2 sessions in Geneva. The chairman is appointed by default, and I think we would have lost that case had it not been for the fact that Ashtar Osaf Ali, subsequent Attorney General for Pakistan, discovered that we had never ratified it. So the theory of a BIT is wonderful. The reality of a BIT quite often happens to be very, very different. And it's not like we've learned this issue. You deal with random bureaucrats and suddenly somebody will say, oh, we've got a BIT. Do you have any comments? You're like, wait, why are you signing these things? What are you doing? For example, we're looking at the WTO framework on investment facilitation these days. That needs to be considered very seriously. What will be the litigation consequences of that? That conversation isn't happening in public, isn't happening at a high level, and may well make us liable in the future. So what do? Well, back in 2016, when Miftah Ismail was chairman of the Board of Investment, there was a meeting. Amr Bilal Sufi, various other people were called, and all of us, all Pakistani lawyers, a number of us making good money from BIT cases said, please stop signing them. Please get out of the ones that you have. If they lapse, let them lapse. If you can terminate them, terminate them. If you can please try and reduce the interpretive discretion given to tribunals, please try and take steps for that. There is a Columbia Center for Sustainable Investment. I had met with them in another context later. I put them in touch. I negotiated a $5,000 fee for a report. I don't think the BOI ever paid them. BOI is simply, in the grand scheme, in the grand bureaucratic hierarchy, a very small portion, a very small cog in the wheel. Normally doesn't really carry that much clout. I was on the board of BOI for 1 year. I don't think we had a meeting, so I'm not sure how functional it is anyways. They're the ones responsible. So if you want to do these things, there is a pathway set out for you. You can have a model BIT more like, let's say, the Brazil style. You can decide that you want to force people to exhaust domestic remedies, but it requires recognition of a problem. And maybe that recognition will only come if Pakistan is forced to pay out, $6 billion. But I really don't want that. At the end of the day, I live and work in this country, and all of us who live and work here and wish the best for Pakistan would rather that disputes did not arise, that we did not have to suffer this penalty. Whether Pakistan has woken up or not, I don't really know. I'm going to deal with one more point, which is to say, how do you deal with the current flow of issues, of disputes coming into Pakistan? And I'm going to talk not about particular cases, but more about the different methods that the different attorneys general have used. Now, legally, yes, I think the Attorney General is the competent entity, but it's more a historical reason that when the first, I think, new BIT case showed up in 2000, 2001, whenever it was, 2001, Makhdoom Ali Khan happened to be the Attorney General, and he got this exit notice, and somebody said, what's this? And he's like, I don't know. So the response from the other, whoever the best lawyer in the world is, and you would go hire that person. And you would hire some very good domestic lawyers as well. And just to give you some examples, in the Impragilo case, which is a case arising, I think, a financial dispute out of Ghazi Barotha, you had Johnny Reeder, I think in those days ranked in a class of 1 by Chambers. You had Alain Bellet, who was one of France's top international lawyers. You had Chris Greenwood, subsequently a judge of the International Court of Justice. You had Rod Bundy, currently ranked in Tier 1. And supporting them, you had Umar Atab Bandial, subsequently Chief Justice of the Lahore High Court, and inshallah, future Chief Justice of Pakistan. That's a team. In the next case that they had Bainder. Alain Pelle was no longer there, but Loretta Malitoki was there. And again, you had Umar Bandial and people of that level. That hybrid model, where you had people from overseas, particularly English barristers, supported by domestic lawyers doing sort of the donkey work, the brunt of the work, I think is a great model. Now, subsequently, we've tried different models. In some cases, we have outsourced them wholesale to, international firms. With great respect, I don't think that works. International firms are money-making enterprises. They're very good, wonderful. Some of them are here supporting this, as they should. But in terms of the institutional imperative, to what extent do they engage with local counsel? To what extent do local counsel learn and become capable of doing cases subsequently? I say this not on the basis of confirmed facts, but I believe that in one of the cases, the major English law firm, which I will not name, sent in a photocopying bill of 10 million rupees. And it was half of sort of the law ministry spoke of nothing else for the next year with the crore rupee ka bill aa gaya. Now, in the grand scheme of things, 10 million rupees for a major international arbitration, those are the costs that you will require, but over here you wouldn't pay that kind of money. So that's one option. Then you have where, occasionally you sort of try to do it through in-house lawyers, and there you have a different problem because of Pakistan's, I think, bureaucratic structure. I think it's a very good move that you have a full-time office in the Attorney General's office dealing with Ahmed Irfan Aslam as the head of the International Disputes Unit. But that unit isn't yet capable of handling this dispute on its own, and it may be a while before it gets there. So we've tried the hybrid model, we've tried the outsourcing model, we've tried the purely domestic model, and I think we're now coming back to, as per my discussions, what I learned from Ahmed recently was that we're coming back to a hybrid model, and I think that is the way forward. The young arbitration group is in part a recognition of the fact that people are interested in this. If there is sufficient arbitration work out there for a full-time arbitration, practice, it's other than Makhdoom Ali Khan, I don't know about anybody doing just that. But hopefully people will learn. But we need to bring in young lawyers, just like Makhdoom Saab did earlier, and I think that's the way forward in figuring out how to have a way in which Pakistan puts forward its best foot and its best teams in the international disputes, which are still likely to rise in the years to come. Thank you.
Thank you very much, Sarah. So how can we prevent disputes, Sarah?
$6 billion question.
Yes.
Yeah, that's the $6 billion question. And I think we've spoken very eloquently. Oh. Can you hear me now? Yeah? I think both of my panelists have spoken very eloquently about the issues and problems that can arise in investor-state proceedings and the burden that can lead a state to be encumbered with. But as Manaz says, we are where we are, so what can we do about it? We have to move forward, and I think Rana Sajjad gave a very inspiring talk this morning about the future of international arbitration in Pakistan, and I think we need to look to the future on how Pakistan can better manage and maneuver in this system, which is for the foreseeable future going to exist. I just want to make three really systemic points on general things that states can do to, better manage international arbitrations and international investment arbitrations, and then if we have time, get into some procedural aspects that states can adopt once they're in proceedings to ensure that their interests are best represented and that they don't fall into some of the pitfalls that states often do. The first is really going back to both of my co-panelists, and that's the review and reform of existing investment agreements. It's very critical, and I know that the Board of Investments here in Pakistan has already started this process, but it's critical that states take stock of their existing bilateral investment treaties and then create a model BIT that is consistent with their social policies, their development goals, environmental, regulatory, public health goals of the country. Now, Pakistan currently has 48 BITs that are signed, 26 of those are enforced, and another 27 of those are currently being negotiated. And again, this is according to the BOI website. So what is critical when you're doing this is really having a well thought out BIT that will capture the state's objectives and help negotiators differentiate between those provisions, which should be negotiable and can actually be changed with their scope for movement, and those which shouldn't be. And luckily, in the last 10 years or so, a number of institutions, including UNCITRAL, the OECD, have done a lot of research and a lot of groundwork on mechanisms that states can use in order to have more favorable or suitable BITs when they're negotiating. Just to give you a few of examples of these, I mean, ways to tailor BITs is to focus on, for example, who can qualify, who can sue. It's up to the states. I mean, the good thing here is it's up to the states entirely on what they want their BIT policy to comprise. So, for example, if you want to limit the definition of investment, a number of states have done this, either to incorporate what has become known as the Salini test and to require a contribution to the host state's economy. You can also tailor the definition of who qualifies as an investor. Some recent new generation treaties have limited, for example, the availability of an SPV to constitute a foreign investor, and now there must be a more substantial business presence, which allows states to require actually substantive investment within their host states. There's also been a major movement to address the issue of regulatory chill, that states are afraid that they're not able to regulate in the public interest because of the limitations BITs might place on them. And so a lot of the newer generation model BITs do address issues like the environment, labor, human rights, and ensure that these are incorporated within the BITs and allow them to have a greater scope for regulatory measures once those BITs are in place. Just to give you some examples of that, and another, I think, interesting example under the Nigerian UAE bid is now also addressing the issue of corruption. I know we're going to have a panel on this separately later on, but that's historically been a very large issue in Nigeria. So the new Nigerian bids have actually addressed corruption within the BIT and defined what that means under those standards. So the first thing, of course, is to look and develop a model BIT that is conducive to the state's regulatory interests, and then also look at what's in place currently and see how you might seek to revise those BITs. The second one, and I think this is of critical importance, is establishing and strengthening investor-state dispute management systems. And for me, this is really where the heart of the issue lies. And that is to set up a strong investor-state dispute management system that enables states to effectively and efficiently manage investment disputes. And we talked a little bit, Faisal talked a little bit about the current system within the AG's office that focuses on international disputes, and I think that is very much a positive development, and I think Ahmed Islam has done a great job of doing that. What is absolutely essential, and you'll see a lot of states who have really been successful in their international investment arbitration disputes, are those states that have internal capacity. They've built specialists within the government that know what the standards are, how to deal with foreign investors, how to prevent investor-state disputes from arising. And those are the states that have been able to effectively manage both prior to the arbitrations being commenced and then once they are commenced. Peru, Colombia, there are a number of examples that Pakistan could look to for these agencies and commissions that have effectively been able to, find out when a dispute arises. Those agencies then look at the feasibility of the dispute. Is this actually something that has teeth, or is it a frivolous claim? They're able to negotiate with investors prior to arbitration being instituted, and then also manage both international and domestic counsel, and then the arbitration proceedings. And I can't say enough, I mean, since moving to Addleshaw, I've had a number of experiences where investor-state disputes have been settled. And the reason they've been settled is because the state took a very proactive approach in managing the dispute once the notice of arbitration, the cooling off letter, arrived on their desk. Now I know that in cases in countries like Pakistan that are facing so many international investment disputes, often a cooling off letter gets tossed to the side, and it's difficult to deal with that immediately because there's so many other things on the table. But really, that is such a key period of time for the state, Most bilateral investment treaties will have a cooling off period, and really if the state can use that effectively in order to engage with the investor, there is a very good chance, depending on politics, depending on the investor and what's sought, to resolve that dispute before ever getting to arbitration. I mean, one can't shy away from the fact that costs of investor-state arbitration are high. Both sides will spend approximately $5 million on average, which means a lot more are spending a lot greater amounts than that, and some less. Each side in terms of their counsel and the tribunal fees, so they're expensive. I had a settlement recently with the government of Malaysia that happened before, after filing the notice letter, but before actually instituting the proceedings, and that was because their AG's office was very receptive. They saw that this was a very powerful claim, and the investor wanted a resolution. Without no investor, I can assure you, wants to be in proceedings for 5 years, just as states don't want to do that. So I think a lot more can be done in the area of mediation, ADR, prior to the actual filing of the request for arbitration, and that is something that very few states take advantage of, and it's been really, I think, underutilized within the system. So having a mechanism of dealing with disputes prior to the institution of the actual proceedings and using that cooling off period in a wise manner is very important. One other note, I guess this is more procedural, is that states can really use this time to do their due diligence, to get their files together. One thing that could be immediately instituted in Pakistan, not immediately, it will take some time and some investment, but to have a system of document management and information. I can't tell you how important it is to have the key documents in any case in order to defend your case. Facts win cases. And when there are files missing, or there's no history of the negotiation with the investor or the bilateral investment treaty, or it's difficult to find and you can't find it for a number of months, you lose critical, precious time. So having systems in place that both lay out the best practices for what you should do and what the Attorney General's office should do when a dispute arises, and also having access to the vital documents that will help you defend your case and potentially win your case are absolutely critical. And that's something that could be done immediately. Corporations are typically organized in this way, and states need to be organized in an electronic, easily searchable manner as well. The other issue is just, in the Attorney General's office, they have a focused group that deals with international investment disputes, but often turnover is quite high, and so people will only be there for a limited period of time. And what is critical is that institutional knowledge doesn't get lost when they leave. And they're all I've dealt with a lot of the attorneys in the AG's office, and they're very bright and capable young lawyers who are enthusiastic and excited and very good at what they do. But the time period that they'll spend there is limited. And so what has to be in place are practices that and procedures, essentially of best practices for how to deal with the disputes, how to manage negotiations with investors, who's in charge, who should be notified, how to get the ministries on board in providing documentation depending on where the investment was made and whose ministry it falls within. So those types of procedures can be tremendously helpful. To move on a little bit to the procedural points, if I have a bit of time, one of the issues just in I've represented both states and investors, and some common mistakes that states make is not really doing their due diligence and using that period of time. I mean, most investors will hire private investigators, for example. States often don't do that, and blanket defenses to state actions are often illegality and corruption. Now, if I'm a state, I am going to, when I get a notice of arbitration, I am going to look into that investor. I am going to ensure that there was no illegality or corruption, both in the acquiring of the investment and also throughout the process of the investment. Who is this investor and what do they represent, and do your due diligence on that, because even if that doesn't kill a case, it can wound an investor to the extent that damages will be significantly reduced. So states should do their due diligence on who their opponents are. Another a mistake I've seen some states make is by immediately filing objections to jurisdiction without allowing the claimants to actually put forward the case. You want to know what that case is. You want to understand what claim you're being faced. How will they frame the issues? What are the issues that you're really going to have to focus on? So let the claimant plead its case. You have until the counter memorial to file any objections. So it's important to get that information out and get as much from the other side prior to the states actually intervening and filing for jurisdictional challenges. Another issue that I find states often do, which I personally find unconvincing, is not engaging in quantum analysis. Now, there's a lot of bad publicity about ISDS and investor-state disputes, but when you actually look at how often states win the majority of times, they win the majority of cases, either on jurisdictional grounds or otherwise. And if you look at the amount of damages claimed, the other issue you see is that typically only about 25% of damages are awarded. Now, some states will make the mistake, I think, of not engaging in quantum. They'll try to simply poke holes in the claimant's assessment of quantum instead of giving an alternative damages model. Even if that is, a much smaller amount of damages, often a tribunal is minded to find liability, but will be sympathetic on the issue of damages. And at the end of the day, that is the amount of taxpayers' money that will be going towards the ultimate award. So it's important to engage with damages, have an alternative model for damages, and also engage with the claimant's damages model, because tribunals want to see some alternative. You must give them something else to decide on. The other issue, and I think this was one that was raised previously by Faisal, is to also do your due diligence on arbitrators. And a lot of times there is not with Pakistan anymore, but with other states, they will appoint someone who is known to them in their jurisdiction, who might not have experience in investor-state arbitration. If this happens, it is very, very likely that that person will be marginalized amongst the three-member tribunal. So you need to choose someone that has that expertise and that will be able to ensure that the respondent state's arguments are considered and given the due attention that they deserve. So arbitrator appointments and choices are another key issue I think that states need to focus on to ensure that they have the best possible opportunity to make sure that their defenses are raised. So with those practical points, I might turn it back over to Sadia for questions.
Thank you very much, Sarah. Thank you very much. That was very helpful. Thanks for all these practical tips coming from you, from the inside, actually, dealing with states and investors. I think it's going to be very interesting now to get an institutional perspective as well, as once you have a dispute, how can you manage it efficiently? So if Ruba could say a few words, that would be great. Thank you, Ruba.
We can't stop all of the cases. How do we make them quicker? So the PCA was established in 1899 as an independent intergovernmental organization to facilitate arbitration and other forms of dispute resolution. So among other matters, today it administers international arbitrations involving at least one state, a state-owned entity, or an intergovernmental organization. Investor-state arbitrations make up the vast majority of our cases. And of those, the majority are conducted under institutional arbitration rules. So all of our cases are ad hoc arbitrations. The Secretary General of the PCA also plays a role in the constitution of arbitral tribunals, either by acting as appointing authority or by designating one. I'll get back to this in a minute. So working at an institution, I may be able to give you a general idea of common issues that cause delays, and conversely, some more procedural practices that may help to expedite proceedings. Because the PCA has administered some speedy cases, some were concluded within a year or less, even when they involve one or more states. But it has also had experience with some of the longest running arbitrations, like Bilcom versus Canada, which is 10 years and counting. But each case is different, of course, but I'll try to provide some strings of logic and insight. So in any arbitration, tribunals obviously will have to balance the two competing objectives of procedural economy on the one hand, and respect for due process and procedural fairness on the other. And when a state is involved or a state-controlled entity is involved, the tension is amplified. But generally, this is because the disputes often implicate public policy and makes them more complex, and therefore requires the tribunal's careful consideration and time. But it also sometimes goes back to the bureaucratic process for the affirmative counsel, and I've heard that come up a few times about government lawyers being well equipped to handle these things. But it also relates to document production and the payment of fees, and these can also sometimes lead to delays. But that's not to say that they're insurmountable or that some parties don't sometimes intentionally employ dilatory tactics. But I just think we should always be mindful of these factors. But because I'm working at an institution, I won't go into delays that are caused by the complexity of the substantive law. Mostly I'll talk about procedural issues that may arise. So I'm going to leave aside the objectively time-intensive task of dealing with very and increasingly complex investment disputes. So why do some proceedings take up more time than others? So some are delayed at the beginning. So under the intertrial rules, a case will start when the respondent receives a notice of arbitration, and thereafter the tribunal will have to be constituted. Some are delayed at that stage. Others are delayed at the very end, where an award isn't issued in a timely manner as when the proceedings are closed. But the majority of the delays relate to the conduct of the proceedings leading up to, and I'll say an award, because I'll talk about bifurcation, which I've also heard a bit about in a minute. But like I said, the PCA administers mostly ad hoc proceedings, so the expediency of the arbitration is almost entirely left to firstly the party's willingness to proceed efficiently, but more likely in accordance with the tribunal's instructions from their discretion to conduct the proceedings in the manner they see fit. In the PCA's experience, this has sometimes led to some creative solutions, even in terms of self-policing of the tribunal and issuing a timely award. And I'll get to that at the end. So we'll start with the good news in the constitution of the tribunal. The constitution of the tribunal can be quick and painless. There are always some safeguarding rules that ensure that a tribunal is actually appointed. So under the intertrial rules, the Secretary General has that role to designate an appointing authority if the parties haven't agreed on one, but the parties can also agree to have the Secretary General himself act as appointing authority, to appoint the arbitrators or rule on challenges to arbitrators. So I'll start with the formation of the tribunal. And I will say this, the proceedings are generally more expedient if the sole arbitrator is appointed, and this is not just goes to the constitution of the tribunal, because it involves only a one-step procedure, but also to the whole running of the case. With just one arbitrator, the time required for extensive consultation in between the arbitrators or exchanging of draft reports can be avoided. But this is rare in cases involving investment treaties, or really involving states, although we have had some experience with this, and at least one occasion, in Pakistan itself has had one case in which a sole arbitrator was appointed in broadsheet. But I will note that neither of these matters involve an investment treaty, and like I said, each case will be different, and there are no hard and fast rules. So I'll walk you through quickly what the process is when we're trying to appoint a 3-member tribunal and one party isn't appointing one, or the arbitrators fail to appoint a presiding arbitrator. So once the first arbitrator is appointed, within 30 days, if the respondent doesn't appoint the second arbitrator, the Secretary General can step in and make a direct appointment of the second arbitrator. Usually when he does this, it'll be a quick procedure. He'll ask for the parties' views and will take into consideration the circumstances of the case. And then if within 30 days of that appointment, the arbitrators fail to appoint a presiding arbitrator, another request can come to the Secretary General by which he can appoint the presiding arbitrator. This is a longer process because it'll involve a list procedure. And I've heard a lot of talk about why it's very important to pick the right arbitrator. And it's very true. It may sound very basic, but arbitrators with time is actually one of the most important considerations. And an arbitrator who understands the procedure and the substantive law that's going to be applied in the case. And so when we're providing the list procedure, we try to take these into consideration as well. So the parties receive the list, they choose and rank their candidates, return the list to the Secretary General, and he makes a direct appointment based on the parties' preferences. And that's how, very quickly, the tribunal can be constituted. I'll now talk quickly about challenges because it also relates to the constitution of the tribunal, but also bridges it nicely into the conduct of the proceedings. Because a party can raise a challenge to an arbitrator at any time of the proceedings. And this can delay the proceedings at the beginning, but it could also delay them significantly when substantial submissions have already been made. So for a new arbitrator to become acquainted with the case, and the proceedings would have to be stayed, obviously, until the challenge is dealt with and or the arbitrator resigns. Because the intertrial rules allow a party to make this request within 50 days of any circumstances giving rise to the potential lack of independence of an arbitrator. In our experience, though, between 2013 and 2018, we've had 50 challenge requests, and they're very rarely upheld. Often it will be that the arbitrator resigns before the case gets completed, the challenge gets completed, or they get rejected by the Secretary General. Like I said, we'll predict nicely into the conduct of the proceeding. So the PCA, like I said, administers its ad hoc proceedings. So in the absence of an express framework, the tribunal has the broad discretion to adopt any methods it seems fit to expedite the procedures. Sometimes it does this by imposing a tighter schedule for the submissions, limiting the length of written submissions, excluding document production, or dispensing with holding a hearing. The PCA has had experience with all of these methods, but some may not be suitable for investment arbitration. Although in some cases, a hearing wasn't held and the tribunal made a decision on the papers only. And broadly, the only sanction available in these ad hoc proceedings is in the tribunal's discretion to make a cost order against the parties when one of the parties unnecessarily prolongs or disrupts the proceedings. So I'll jump into give an example of one of the procedures that I think do generally expedite proceedings, although I can tell from my panel discussions that these may not always work. So because the PCA doesn't have a rule akin to the Exit Arbitration Rule 41, where frivolous claims or defenses can be summarily dismissed, the way that we could work is when parties bifurcate the proceedings into separate phases. This makes the issues in dispute more narrow, and it can reduce some of them as they are dismissed. But like what the panelists did say, that sometimes the tribunal prefers to make this determination once it has viewed the submission. So a party can present this request to bifurcate proceedings, and it is often in the jurisdictional phase, but the tribunal may choose to defer this question until it has received at least first rounds of submissions to see whether it would be efficient or expedient to bifurcate the proceedings. And also, in our experience, like I said, sometimes we dispense with the hearing, especially in jurisdictional phases, which makes it go a bit quicker. But then, as I said, a key disadvantage is sometimes some parties may just be employing a dilatory tactic, and it would require a hearing from a procedural hearing from the tribunal and an exchange of submissions on whether or not to bifurcate, and this may prolong the proceedings. So I'll give some statistics on whether, and leave you to decide whether or not you think bifurcation would work. But when we've had bifurcated cases, the conclusion from the date of the start of the proceedings until the conclusion of the case, it took only 3.5 years. And where it was dismissed on jurisdiction, the case only lasted an average of 3.2 years. And this does include constitution of the tribunal and exchange of submissions. I should note, however, that I did mention Capone at the beginning, and Capone was a bifurcated case and has even now had a deferred decision on costs to be issued in a separate award, which kind of makes it trifurcated. And it's taken a long time. But like I said, no harm in past rules, so it really does depend on the case, and that case is very complex and did involve a lot of procedural steps. Another issue that I won't delve into very quickly because I'm conscious of the time, is interlocutor applications. Parties can make these provisional applications to preserve the integrity of the proceedings, but they can cause delays. And an added complication in investor-state disputes is the state sovereignty element, and any request for provisional measures of specific performance has to be considered against the incursion on the exercise of state sovereignty. And these come again with respect to requests to enjoin parallel domestic proceedings. And also inversely, we can see it where domestic proceedings are underway, the tribunal may choose to stay the proceedings of its own accord or at the request of a party, and that can also lead sometimes to delays. There's not much that can be done about these, and like I said, they sometimes serve a very good reason. Yes, service. So now we're coming to the end of the proceeding stage. So this is when the party issues, tribunal issues its award. Like I said at the beginning, many arbitrations are delayed because the arbitrators may be delayed in issuing their awards. This can be due almost always due to an inability to find a convenient time for all of the arbitrators to meet. Arbitrators are generally very busy people, and as we all know, they do get a lot of repeat appointments. So to find the time not only for them to convene for hearings, but also then to convene for deliberations, exchange draft awards, and discuss them, be happy with them, sign them, and exchange to the parties will take a long time. And given the ad hoc nature, again, it's completely within their gift to take their time with issuing an award. But like I said, we've had some interesting takes on encouraging efficiency. In one of our cases, the parties agreed on a timetable for the tribunal to issue rulings, and if it failed to issue a ruling within that specified period, the tribunal would have to provide regular updates to the parties on the status of drafting the award. And that was every month that it exceeded the time limit provided for them to issue their award. I will have to say this, it didn't work as well as hoped, but it was a very welcome suggestion and creative solution for the tribunal of the parties. And then, unlike ICSID again, the PCA doesn't have a second tier mechanism for annulment. So this also reduces the duration of the proceedings, and then we leave it in the hands of the domestic court. There are a number of other issues that may arise that will complicate and delay proceedings. So for example, there are added complications from concurrent proceedings, as Pakistan undoubtedly knows, as well as applications to domestic courts, which I briefly mentioned. But there are other ways in which domestic courts and international arbitrations intersect, including and especially in enforcing awards. But that brings its own host of issues, and I won't get into that. And I will end as the PCA does with the issuance of the award. Thank you for your time. I look forward to hearing your questions.
Thank you very much, Ruba. Thank you very much for this very interesting presentation on the tips to manage the case when it's there, from the procedure's point of view. Before opening the floor to your questions, which we're going to take, I'm just going to turn to my panelists to see if they have specific comments to make on each other's presentations. I'm sure they do. So if you could keep it to a short point, that would be really great. But I know that I think, Vesa, you had some points on Sarah's presentation. Notably, you wanted to discuss on whether or not settlement can work and to what extent with respect to Pakistan.
Well, I think our point about settlement was excellent. I just wanted to say that in the specific context of Pakistan, we've had huge problems making that work. To give two examples, in the case of Karki, there was actually originally a settlement which was then overruled, not directly overruled, but essentially the Supreme Court of Pakistan said to the chairman Nab, if subsequently they are liable, then that money will come out of your own pocket. So that type of virtue signaling is a constant problem. The same thing happened in the case of Reko-Dik, where there were, I believe, multiple settlement discussions at different points in time. And if you ask people, there was always a demand that it should be the lowest possible figure. And then you also had, it became a political football. People used to talk about it in the press, and supposedly national interests were being sold out for a song. So the political pressure was also huge. And now, currently in Pakistan's sort of bureaucratic climate with the National Accountability Bureau, it would take a very, very brave person to sign off on any amount. So normally it's difficult. Over the past few years, it has become more difficult, and given the fact that every decision is subject to personal liability and potentially a jail sentence, as I said, anybody who actually wants to sign off on a deal would be very brave indeed. And this is a terrible thing. I'm not saying it's a good thing. We should settle, we should be sensible, we should be commercial. We're just not going to do it.
Sarah.
I think that's an excellent point. A lot of times settlement is really the luck of the draw, and certainly in all the cases that I've settled, there happened to be a perfect marriage of either a political transition, so i.e. a new government came in and they could blame this dispute on the old government, so they had a little bit of breathing room in order to settle. Where I find settlement has been most effective is actually before proceedings are even commenced, i.e. when the dispute itself is still confidential. It's not in the press, because the press is a whole other reason why settlement doesn't happen, right? Everyone's afraid that they'll be accused of reaching a deal that betrays the country. So I find settlement is most effective prior to the issuance of a dispute. So when the notice, the cooling off period is sent. I've also found that in terms of damage, that's another good point. Most of the settlement in negotiations I've been involved in, the investor will actually provide its initial damages assessment to the state on a without prejudice basis. And then the state perhaps will also have an independent consultant that will look at that, poke holes in it. And so they're essentially having a separate little quantum phase, confidentially, without prejudice. And I find that the numbers in those negotiations are far less than the numbers that you get when you're in an international arbitration proceeding. So I think doing it early, doing it before it's public, and actually having the investor and state being willing to open, because obviously the AG's office has to have a basis for any payment. So there needs to be a showing by the investor of what it would be entitled to. In terms of personal liability, and I know NAB has been a huge issue here, that's a problem, and I think that it needs to change, because that no one's going to want to sign off on a deal that they're going to go to prison for, and it's just not worth it. And so what happens then is it becomes everybody else's problem, and it gets pushed and it gets pushed. So ultimately, no one will settle. You end up going through an extremely expensive arbitration process, and then you get a very large damages award against you. I mean, what has to be thought about is what is in the long-term best interest of the country. And so perhaps it is reforming those laws so people aren't personally liable. So, people within the AG's office that have the specialist training are able to actually negotiate these deals and come to a settlement, like other countries have been examples of. I realize that's not currently the case here, but perhaps that's something to look at.
Manaz, a few words?
I think, you've got issues of accountability and transparency, and you want to sort of keep those at bay. I mean, I agree with you. Settlement is absolutely the way forward. How do we do it? That is a big question. And one idea is perhaps to give the government officials the comfort to be able to do it by perhaps having an external committee or a mediator, to kind of share that responsibility of signing a check on behalf of the government with an external panel. I think that would increase accountability, transparency in a managed way, because somebody's watching. And also you have the opinion of an independent body saying, look, this is perhaps what you should do, not your own counsel, but somebody else saying, look, this is a good idea, this is the number you should go for, get quantum experts. So I think my sort of advice is to formalize the settlement process somewhat, rather than just do a deal.
Great point, Manaz, and I just am going to put in a little bit on the Singapore Convention here, because I'm on the IMI Singapore Convention Task Force. There's been a new convention to actually try to formalize settlement and make essentially what is the New York Convention on the Enforcement of Arbitral Awards, just give the same enforceability to mediate round of settlement negotiations. Is often there are things that can be given to an investor during that process that are not compensation, right? So perhaps it's the extension of a license, or it's an interest in a new project. It's something that can be mutually beneficial to both parties, as opposed to just an outright check for the claimant. So that's another, I think, advantage of mediation or settlement, is that it can encompass things that aren't just quantum, because no one wants to write a check at the end of the day, do they?
Well, thanks for your comments. That's very timely. I think people are listening carefully. We're going to open the floor to some questions. I think we're going to take a couple at a time. Unfortunately, we are well above our time, as you can see from the program. So we're going to, of course, we want to encourage discussion, so give us our questions, and if we can't all respond to them, we'll continue the discussion over coffee break. But please, if somebody has a mic and we can, please, forward.
Thank you for the conversation so far. Just a very quick question. Given that we are in a very litigious environment in Pakistan, how does the panel think we can overcome the constant challenge in local courts, domestic courts, to international arbitration proceedings, awards, processes, appointments, almost everything that happens in arbitration then gets replicated in local courts, which changes the nature of the arbitration process?
Maybe you can address the question.
I think the simplest way of avoiding that would be to have the session for judges. So perhaps they can learn what the law is, because otherwise you wind up reinventing the wheel many times over. We're still sort of unsure as how to deal with it. Even the New York Convention, the points left untold. But essentially, there's no option but experience and education and outreach to the judicial community, and perhaps politely explaining to them that this is how things work.
I completely agree, Faisal, and some good examples of that are in Brazil, for example. The ICC has done tremendous training of Brazilian judges on getting them comfortable with arbitration. Previously, they were very hostile. Now they're extremely friendly to arbitration. Similar with the Georgia International Arbitration Institute. It was only a couple of years back where the Georgian courts were very hostile to arbitration. Judges felt that that was taking, part of their jurisdiction away. Most courts are overburdened in any different country. And once judges appreciate that arbitration is actually a means of reducing their docket and allowing them to have a lighter load, and they're aware of the actual benefits of arbitration. Once they are educated on this, there's been a lot of improvement, and judiciaries are quite happy to take it on.
Sorry.
This might be a task for CICA.
Just to add, you also need a new law. I mean, if you need to begin by changing your domestic law of arbitration, getting rid of the 1940 Act, having a modern law based either on English law or ancestral modern law. And once people learn, the judiciary learns to trust arbitration, then that will carry over into the international field. Right now you have sort of a schizophrenic situation in which you have a domestic law which sort of all but invites intervention, and then an international law which is supposedly completely different. And obviously you're going to have some confusion.
I think you need a slight attitude change as well. You can't just like arbitration if you win, and you can't hate it if you start losing. And I think you really have to embrace the process as a fair means of resolving disputes. And as long as it's a fair fight, you will have these skirmishes, and eventually order will hopefully be restored if you have cost consequences, for example, or people realize how the system works. But you really need to embrace it. And I second what both my friends in the panel have said. You can't just pick and choose, and there's a bit of schizophrenia there where sometimes you push arbitration forward, then you take one step back, then you pick and choose according to your convenience. I think you're either embracing that process as a fair means of resolving the dispute, even if you lose or you win, or you realize that this schizophrenia and chaos is going to continue.
If I may just add, I think there also, because we're on the investment arbitration panel, I think there might be a confusion also in people's mind as to how much the courts or the domestic courts can be involved or should be involved in investment arbitration proceedings. And there's a clear distinction between ad hoc proceedings and when you're going to seek enforcement or interim measures and etc. You're going to seek going to go to the courts for enforcement, and then the New York Convention comes in and etc. And then exit proceedings or other institutional proceedings, and I'm talking about exit in particular, where when you get an award, then it's enforceable directly. It's you don't need to go to the courts normally for enforcement. Of course, the courts have a role to play, but less so. Now, where the role of the court is important, though, is understanding that their actions and their decision could constitute a breach of the treaty itself, also, like typical denial of justice claims, for example. So that's just to keep in mind as well.